Now, when the Gender Representation on Public Boards Scotland Act was passed by the Scottish Parliament in 2018, it set a 50% target for the number of women on public boards in Scotland. So far, so uncontroversial. Since then, the definition of a woman in this context has led to a series of legal challenges, and the debate has heated up significantly as a result. Well, that's taken matters to the UK Supreme Court tomorrow, where an appeal by the campaign group for Women Scotland will be heard, and we can hear more from our Scotland correspondent, Lorna Gordon. Just tell us more about how this case has come about, Lorna.
Yeah, Julian, as you say, it's been a long-running legal battle traced back to this act in 2018. That law's definition of women included people who were living as a woman or currently or proposing to undergo gender reassignment process. It was challenged by 4 Women Scotland, whose position is that sex is a biological fact. They won in the courts, but the Scottish Government then amended the bill and there was a fresh judicial review. That time around, the Scottish Government won, and the court ruled that sex was not limited to biological or birth sex, but also included those in possession of a gender recognition certificate. So, as you say, it's now ended up in the Supreme Court for a definitive ruling. 5 judges having to decide what, in effect, when it comes to the law, is a woman. Now, 4 Women Scotland say that if the Scottish Government definition holds, it'll have far-reaching consequences for single-sex spaces like shelters, lesbian gatherings, sports events, hospital wards. The Scottish Government says the law is clear in this area. Transgender campaigners say that if 4 Women Scotland win in their appeal, it could erode the protections they have under their reassigned gender. So strong feelings on all sides, but everyone actually hoping for a definitive ruling by judges in this 2-day hearing, which gets underway tomorrow.
As you say, contentious everywhere, but perhaps particularly so in the context of Scottish politics?
Yeah, absolutely. There's been a high-profile debate in Scotland where I think it's fair to say that the theoretical has become quite tangible. It started with Isla Bryson, who was a transgender double rapist who was initially remanded to a women's prison. The then First Minister, Nicola Sturgeon, struggled to state whether or not, in her opinion, Isla Bryson was a woman. There was the Gender Recognition Reform Bill, where a large majority of MSPs backed streamlining the process by which someone could get a gender recognition certificate, essentially bringing in self-identification. That, of course, was then blocked by the UK government, which claimed it would significantly impact on the Equality Act. That's the act that's going to be debated at the Supreme Court. I mean, politicians, I think it's fair to say, have tried to steer clear of it. And it's now fallen to the court, to the judges to adjudicate and give it a definitive decision.
Lorna, thank you very much. Well, to consider what's at stake for the two sides here, I've been speaking to Susan Smith, co-director of 4 Women Scotland, which has brought the case, and to Emily Chung, who is co-convener of Out for Independence, the official LGBTQ plus wing of the Scottish National Party. To Susan first, what did she fear would happen if the Supreme Court rejected her position?
If we were to lose, then the definition of sex and the definition of men and women would be dependent on whether or not somebody had one of these certificates. And this has implications, obviously, for women and the operation of single-sex spaces. It would have implications for how, for example, we run prisons. We've already seen some male prisoners being sent to female prisoners, some incredibly violent. What happened in Ireland was that when a version of self-ID was passed and prisoners got hold of GRCs really easily, they were able to take the Irish government to court for breaching their human rights because they were legally female and they were being placed in a male jail. So they had to move some of these incredibly violent people into female prisons. So that's one social aspect. But there's also issues for, we've got interventions from gay and lesbian associations, because associations are not covered by exceptions. There are exceptions in the Equality Act which do make some allowance for excluding people with a GRC, but associations are not covered by that. And our lesbian colleagues are really worried that going forward, they're going to have to accept a lot of men into these groups. And there are, unfortunately, quite a lot of men who do want, for whatever reason, to identify as lesbians. It used to be a Bernard Manning joke, but unfortunately now for a lot of these women, they say it's fast becoming a reality.
The accusation that will come your way, you know this very well, is that you are anti-trans in the stance that you're taking here. How would you respond to that?
I think our organisation and this action is about women. It's about being pro-women, and it's about protecting women's rights, which it's taken us a very long time to get to this point, and it's taken our gay and lesbian colleagues a very long time to get to this point where sexuality was recognised under the Equality Act. If we lose, sex and sexuality are both rewritten in law, and we lose a lot of the rights we've enjoyed. So I suppose you can only characterise us as being anti-trans if you think that women and gay and lesbian people having their rights protected by law is somehow problematic.
Can the two go hand in hand? Can you be...
Absolutely.
That seems to be a significant problem by law in this country at the moment. So how would you end up in a situation where the two do go hand in hand?
Well, for the most part, people do not need to be segregated by sex or segregated by their sexuality or by their race or anything else. The law is there to protect people in the instances where that really, really matters, where they need access. For example, women need access to a rape crisis shelter, or where you're in hospital and you need care for a sex-specific condition. And also you need perhaps research done on how a heart attack affects a man and a woman differently. All these things are dependent on sex. So it's quite important we have crystal clear definitions of this. So generally, there shouldn't be a problem. And there are all sorts of ways that we can protect every group individually and separately and cater for their needs. What this is about really is about people wanting to ensure that women no longer have the right to access to spaces and services. And that to me doesn't seem terribly progressive. That seems like a very regressive thing to do. It's something a few years ago, I think people would have been shouting it down as some of the worst excesses of misogyny or the kind of incel movement.
Susan Smith from For Women Scotland. Well, now to Emily Chung, who rejects the reasons for the appeal and who represents LGBTQ plus people in the Scottish National Party.
Our objection is that we think the decisions made by the Supreme Court at the moment have actually been very appropriate. There's a focus on the realistic day-to-day application of the law that we feel is very, very helpful for actually when this law will be used. So, for instance, this is in reference to particularly affirmative action plans, and ultimately, whilst we can talk about kind of the specifics and the abstracts, in the realistic day-to-day, when this will be used, in the vast majority of cases, it winds up just making sense to include trans women in the overall classification of women for these purposes.
That's where the difference lies, isn't it? Because FWS would say that, of course, we should see rights enshrined in law for trans women, but they argue that these rights should be protected in legislation separate from biological women's rights. Now, why do you resist that?
I think the best way to explain this is with an example. So say you're running one of these affirmative action plans. So you have, say, a board and you're looking to get 50% women. And you have an applicant who walks in. Let's call her Jane Doe. She has long hair. She uses she, her pronouns. She's called Jane. She's maybe dressed quite femininely. In those situations, socially, you're not really going to be doing any of the tests that would distinguish a trans woman from a non-trans woman. So it wouldn't make sense to include them as separate.
Can I extend the boardroom analogy, though? Because FWS have done this. They say that if this hearing goes in the direction that you would like it to go to, you could end up conceivably with a public board comprising 50% men and 50% women with certificates who were born male. And they question what that does for gender equality.
To be honest, I think it's astonishingly unlikely.
It is astonishingly unlikely, I acknowledge that, but under this situation that you are legally pushing towards, that could happen, couldn't it?
Yes, but I don't feel that would defeat the purpose. Trans women socially live as women for the vast majority of situations. My understanding of their objection is that it would lead there to be only a male perspective in the boardroom, but that to be honest, kind of avoids the lived experiences of trans women. Being a trans woman fundamentally changes your experience. For example, if we take one of the common reasons why, for instance, people ask for more women in the boardroom is a greater level of sensitivity towards, for instance, pregnancy leave, maternity leave. You know, obviously trans women can't get pregnant, but they do often have to have extensive medical interventions. So they're more likely to be sympathetic to that.
For Women, Scotland talks about the wider potential ramifications of this hearing if it goes in the direction that you would like it to go to. And they raise the issue of who can access single-sex services, certain protected spaces, which is obviously a well-explored area. They have concerns about that. Why do you say they shouldn't have concerns about that?
There's two concerns. The first is a practical matter, is that they oppose it on the grounds of they feel that gender recognition certificates rather, shouldn't grant access to single-sex spaces. The answer is that they don't. The second argument is, again, somewhat of a sad one, which is that there is a presumption in the For Women Scotland's argument that same-sex or single-sex female spaces in particular are free of physical and sexual violence. And sadly, that's simply not true. Sadly, biological women, cis women, can and do commit horrible acts of violence, including sexual violence, including rape, on other biological cis women.
Emily Chung from Out for Independence on tomorrow's Supreme Court hearing on the legal definition of a woman.